We are wanting to do just a very quick summary, maybe some key takeaway points, which I think you've covered very nicely, a wonderful presentation. But if either of you have just a very quick 30, 40-second key takeaway that our attendees could have, and then if we do have questions, what we can do is we can submit those again. And a reminder, attendees, you do have the contact information available for you on that chat window. But I do want to just very quickly, before we close, just any final summary of what our attendees can take after all of this extensive information. And we'll begin with you, Kurt, just about 30 or 40 seconds or so.
Sure. So I touched on a few different issues, and I think the theme is that things are changing a little bit, maybe not as much as we or some expected, but securities enforcement is slowing a little bit. The priorities are shifting, and I think the legal landscape, at least in terms of cases coming out of the courts, are changing the game a little bit. So just stay tuned, stay on top of these issues, because I think we are in a bit of a transitional period.
Thank you so much. And Susan, any final thoughts you have?
I would just say be prepared. It's generally, good corporate hygiene in terms of your accounting records to make sure as you're going through and entering transactions that you have support for them, and if there's key judgment areas that you really thought hard about, make sure you're documenting that. That way, down the line, if a whistleblower goes forward with something they weren't happy with, or even if your auditors come back at you with questions, you'll have right there in front of you the basis for your decision. And then, worst case, even if you got it wrong, as long as you were acting in good faith and you're able to present that it might be an error that can be corrected, but it doesn't result in something much more significant, for example, a fraud charge or major penalties as a result.